So good afternoon, everybody. Thank you very much for attending our webinar this afternoon. I'm Leonie Parkin, and I'm a council member at Bristol Law Society and an in-house lawyer at Computershare Investor Services plc. We're delighted to welcome you today to our webinar on arbitration, the reluctant party, about which Nigel is going to give his presentation shortly. Nigel, as many of you know, was a partner at Vilvo's Revisards until recently and is a fellow of the Chartered Institute of Arbitrators and a professional mediator. Nigel, I will turn over to Nigel shortly, but just a little bit of housekeeping before we begin. Nigel will speak for approximately 40 minutes today and will present his question, and there'll be some time for questions at the end. You can present your questions via the Q&A function, which should appear at the bottom of your screen, and then I'll pose the questions, time permitting, at the end. Just to remind you that this presentation is being recorded today and will be available on our YouTube channel after the event. And I think that's all from me. So without further ado, I will hand over to Nigel for his presentation. Thank you very much.
Thank you, Leonie. Good afternoon, everyone. I'm sorry if that sounds rather like Richie Benaud. I'm going to talk to you about how an arbitrator can deal with a reluctant party. Arbitration anticipates that the parties to it will cooperate in order to achieve a determination of their dispute. This is because they will have contractually agreed to arbitration as their chosen dispute resolution method before any dispute arose, or they will have agreed to arbitrate after one has arisen. But what happens when such cooperation is only reluctant, partial, or even absent altogether? As I'm sure you're aware, arbitration is governed in this jurisdiction by the Arbitration Act 1996. I will refer to that as the Act, and when I mention any section number, it will be from that Act. Crucially, the Act allows, and indeed encourages, the parties to arbitration, if they can, and subject to legality, to agree various aspects of arbitration procedure, including the ambit of their arbitrator's powers. However, where the parties cannot agree, which I have to say is usually the case, then the arbitrator decides the procedure, the timetable, and the ambit of the necessary evidence. So, against that brief background, and to place the problem of a reluctant party into both a statutory and a practical context, I'm going to cover an arbitrator's general duties, powers, and available remedies, the interplay of relevant arbitration practice guidelines, the party's own duties, how costs work, how the Act treats the parties differently in this area, possible solutions that an arbitrator can adopt, and finally, a possible solution of the parties that has recently been introduced by the Institute of Arbitrators. First of all, what are an arbitrator's general duties, powers, and remedies? An arbitrator has a clearly defined statutory role, duties, and responsibilities. Essentially, Section 33 of the Act requires an arbitrator to act fairly and impartially between the parties. More specifically, an arbitrator should give each party a reasonable opportunity both to put their case and to respond to the other party's case. The arbitrator should adopt suitable procedures and should avoid unnecessary delay and expense, which is a very important aspect of the statutory duty. And lastly, an arbitrator should provide a fair means to resolve the issue or issues that the arbitrator has to determine. To fulfill that role, an arbitrator can exercise various general statutory powers, subject to the parties agreeing something different. Under Section 38, an arbitrator can order a claimant to provide security for the costs of the whole arbitration. An arbitrator can give directions regarding the inspection, preservation, custody, or detention of any property which is the subject of the arbitration, involved within it, or which is owned or possessed by a party. An arbitrator can direct a witness to be examined on oath or on affirmation. And finally, can direct a party to preserve any evidence in its custody or its control. Subject to the parties agreeing something different once again, an arbitrator's available statutory remedies are as follows: to make a declaration, to order the payment of money, to order a party to do or to refrain from doing anything, to order specific performance of a contract, except one relating to land, and to order the rectification, setting aside or cancellation of a deed or document. So against those powers and duties, how do the various arbitration practice guidelines assist where there is a reluctant party? The Institute of Arbitrators has produced a range of practice guidelines, and one of them deals with party non-participation. Although these guidelines address the situation where a party does not participate at all, they are equally relevant to where a party participates only selectively or only up to a point in time. All these situations are complicated by the fact that, as the law stands, there is no arbitration equivalent of civil litigation's default judgment or its summary judgment on the application of a party. Although the parties could agree that their arbitrator's powers can include the ability to receive and determine an application for summary judgment, I have never had any party even suggest that. Importantly, if a party does not participate or does not participate fully, the arbitrator can, and indeed should, continue with the arbitration. This is so as to avoid delay and or prejudice to the other party or parties who are complying. Remember, that's one of the statutory duties under Section 33. What the guidelines require is that an arbitrator should then do 5 steps. First, check that any non-participating party is actually aware that the arbitration is on foot and of what is required of them. Second, check that there is no underlying, as yet no doubt undisclosed, challenge to the arbitrator's jurisdiction or appointment. Third, continue to encourage and, if appropriate, to facilitate any non-participating party to resume their participation in the arbitration. Fourthly, to continue to keep any non-participating party informed of the progress of the arbitration, including, most importantly, highlighting any action steps and the timing for them that are required by that party under the arbitrator's directions or orders. And finally, and this is important, record in any award that party's non or partial participation and the steps taken by the arbitrator to address that. All these steps, and in particular the last one, are very important to try to minimize the chance of successful appeal by a non-participating party against an arbitrator's final award. This would probably be on the ground of perceived bias by that party, thinking the arbitrator not to be even-handed or impartial, or a perceived lack of an opportunity by that party to present their case. Now, alongside the arbitrator's duties, what duties fall upon the parties themselves? Helpfully for an arbitrator, and somewhat unusually it has to be said, Parliament saw fit to place specific obligations on the parties to an arbitration as well. Section 40 requires that each party should do all things necessary for the proper and expeditious conduct of the arbitration, that they should comply without delay with any determination by the arbitrator on procedure or on evidence, or with any order made or direction given by the arbitrator. And lastly, that they should take steps without delay to obtain a court decision on any preliminary question of jurisdiction or of law, if one is appropriate. So I now turn to how the costs position works in an arbitration generally, and how it may differ if there is a reluctant party involved. The basic position is that the costs of an arbitration include the party's legal costs, any appointing institution's own charge for making the appointment, and the arbitrator's own fees. Under Section 28, the parties are jointly and severally liable to pay the arbitrator's reasonable fees and any expenses, although a party can apply to the court to have these assessed. Sections 59 to 65 deal with costs in rather more detail. Again, the parties have considerable scope to agree or to limit an arbitrator's power on costs. However, if they don't agree, and remember that they seldom do, then Section 1 empowers an arbitrator to make an award allocating the costs of the arbitration between the parties on the usual general principle that is familiar to you, that costs should follow the event, unless that is, the arbitrator is satisfied that this principle is not appropriate in any particular case. Under Section 63, and again subject to the parties' contrary agreement, an arbitrator may determine by award the recoverable costs of an arbitration between the parties, and must specify the basis of that award and the description and amount of each recoverable cost item. The guiding statutory principles under Section 63, subsection 5 are that, on assessment, an arbitrator should allow a reasonable amount for all costs reasonably incurred, and that any doubt should be resolved in favour of the paying party. Now, you will note that there are many essential parallels here with the cost regime in civil litigation. However, in an arbitration, there are four crucial advantages. First, the costs process can be as flexible as the parties wish. Second, it can be completed far more quickly than it is often the case in litigation. Thirdly, the parties are expressly encouraged to agree costs, or at least aspects of the cost process, if they can. But most significantly, in my mind, there is no cost budgeting in arbitration, and therefore all the associated problems, dangers, or implications flowing from that never arise. That's all quite straightforward, but what if one party, and it's normally not the claimant, decides not to participate or to participate only selectively in the arbitration? This can provide a difficult and indeed delicate challenge for an arbitrator. In many ways, party who chooses not to take part at all is easier to deal with. The arbitrator just has to follow the practice guidelines that I've already outlined. But what of the party who takes part only selectively? That party may, for instance, serve details of its own case and defend the other party's case, and yet refuse, or perhaps be unable, to pay its share of the arbitrator's fees as the arbitration proceeds. Now, this is the area where an arbitrator has to tread carefully. While an arbitrator has specific conditional powers, including cost powers, to address a party's default under Section 41, and I'll expand upon these shortly, an arbitrator must always balance the essential statutory duties to act fairly and impartially between the parties and to provide a fair means of resolving the dispute with the duty to avoid unnecessary delay or expense. So you can readily see that to be too robust risks a challenge to the eventual award under Section 68 by the part performing party, who would no doubt argue that the arbitrator had failed to comply with the general duties and was therefore in some way biased against that party. Conversely, to be too lenient towards delay or non-performance risks a similar challenge by the compliant party. The Act, in fact, treats the parties differently in this area in a number of ways. First of all, as I've already mentioned, under Section 38, an arbitrator can order the claimant to provide security for the costs of the whole arbitration. This might be achieved by paying the estimated overall costs to a third-party stakeholder, to any appointing institution, to the claimant's solicitors against their undertaking to hold that security to the arbitrator's order, or in the last resort, to the arbitrator. However, there is no power to order payment of such equivalent security by any other party than the claimant. This is despite the fact that all the parties have the same contractual obligation to arbitrate, which I mentioned at the beginning, and otherwise the same statutory duties once an arbitration has commenced. So, having chosen to invoke the arbitration agreement, from that point a claimant has to beware of failing to comply with orders or directions. Otherwise, an arbitrator could make such an order against the claimant. Secondly, if a claimant fails to comply with an arbitrator's peremptory or unless order to provide security for costs, the arbitrator may dismiss the claim under Section 41, subsection 6. This security for costs may either relate to the costs of the whole arbitration or indeed just to the arbitrator's fees. It has become usual practice for arbitrators, backed by the general cost-sharing rule in Section 28 and by the rules of the various arbitral institutions, to require each party to pay an equal amount to the arbitrator as security for the arbitrator's fees at the outset of the arbitration, and then further equal payments as appropriate as it progresses. In this way, the arbitration should be able to proceed to time, free of any potential complications that might be caused by non-payment of the arbitrator's periodic invoices by one party. Those invoices can, of course, be paid from the security held. However, again, there is no equivalence action available to an arbitrator where a party other than the claimant fails to provide security for costs. And I'll address this shortly Lastly, unless the parties have agreed otherwise, for obvious reasons they're unlikely to do this, under section 43 subsection, section 41 subsection 3, an arbitrator may dismiss a claim. Before doing that, an arbitrator has to be satisfied that there has been inordinate and inexcusable delay by the claimant in pursuing that claim, and also satisfied that such delay has caused or may cause either substantial risk that it is no longer possible to have a fair resolution of the issues, or serious prejudice to the other party. Once again, there's no similar sanction for a dilatory respondent. Clearly, these statutory imbalances can cause frustration and resentment to a claimant who is, after all, merely following the dispute resolution process that the parties had already agreed. As I mentioned, an arbitrator has to provide a fair means of resolving the dispute, but these statutory imbalances between the parties can make that difficult. With this problem in mind, in suitable cases, I like to give the parties the option that I can conduct a short and simplified form of arbitration in order to save them time and cost. This is particularly apt in a case that is clearly going to be lower value and a paper-only arbitration with no need for an oral hearing. However, this is seldom attractive to more than one party, possibly because it is seen as unfamiliar, or possibly due to a concern that this may not necessarily enable a party's best case to be put forward. Whatever the reason, if such a process could be agreed, it would save a lot of time and cost, which in turn might avoid or at least reduce the problems that partial non-participation of a party can cause. So apart from that, what other options or solutions are there? Well, there are three provided by the Act and one which has recently been introduced by the Institute. First, the statutory ones. The first of these, if an arbitrator has ordered the parties to provide initial security for the arbitrator's fees, and any party fails to pay without establishing sufficient justification for not paying, then under section 41 subsection 5, an arbitrator can make a peremptory order to the same effect, but substituting a new deadline for compliance. If a party doesn't pay after that further deadline, then any other party to the arbitration can issue separate proceedings in the High Court to enforce that peremptory order. Before doing that, the arbitrator would have to give their prior permission. In fact, the arbitrator has the power to issue such enforcement proceedings. However, in practice, it is far cleaner and simpler to leave it to the compliant party or parties to do so. Therefore, it is possible to have the arbitration and interim enforcement proceedings in court running at the same time. If this happens, there is no requirement that the arbitrator should stay the arbitration, and indeed to do so would be unfair on the compliant party or parties. This very situation, but with the rather surreal embellishment that in the enforcement proceedings, the respondents, who had been participating only intermittently throughout the arbitration, then argued that I had never had jurisdiction to conduct the arbitration, that my interim award was wrong in law, and that it had been reached by a serious irregularity. Reassuringly, the High Court found that the respondent's time for mounting any jurisdiction challenge had long since expired, that they'd not exercised any of their statutory rights of appeal within time, and that the enforcement proceedings were not the correct forum to try to raise such matters anyway. Secondly, if any party is in default of a peremptory order other than one for the payment of security for costs, then under section 41 subsection 7, an arbitrator may direct that the party in default cannot rely on any allegation or material that was the subject matter of that peremptory order. Second, the arbitrator may draw such adverse inferences from the default as the circumstances justify. Third, an arbitrator may proceed to make an award based solely on such materials as have been properly provided. And lastly, may make an order regarding payment of any costs incurred due to the default. So this is the cost implication for a non-participating party that I mentioned a few minutes ago. So an arbitrator does have some teeth, but striking out a claim or a defence is not possible for this specific default. Third, under section 41, subsection 4, if a party fails to attend or to be represented at an oral hearing of which due notice has been given, or for a paper-only arbitration, fails after due notice to serve written evidence or to make written submissions, then the arbitrator may continue in the absence of that party or without that party's written evidence or submissions and make an award on the basis of the evidence properly submitted. Those are the only three statutory remedies available. However, as a matter of commercial reality, I have to mention that there is the Institute's own recent solution. The Institute recently introduced a business arbitration scheme for financial disputes involving between £5,000 and £100,000. By using this scheme, the parties can avoid some of the problems that I have mentioned. The scheme provides for an arbitration with a fixed duration, at fixed cost, and with limited cost recovery between the parties. In detail, statements of case and written evidence may not exceed 5,000 words per party, and a set timetable requires a single arbitrator to issue an award without any oral hearing within 90 days from the arbitrator's appointment. Arbitrators, who must be a fellow of the Institute or above, are appointed by the chairman of the Institute's branch that is local to where the claimant lives or works. Each party has to pay a fixed fee of £1,250 plus VAT to cover both the Institute's administration charges and the arbitrator's fee. Cost recovery between the parties is limited to £1,000 plus the Institute's fixed fee. So you will appreciate that this is certainly a cheap and a relatively broad brush solution. And while it may not be suitable for all disputes, it is nevertheless an option for the parties to consider in a relevant dispute. Since often a party's reluctance to participate or to participate fully is, in my experience, driven by concerns over the cost and the length of a traditional arbitration process. Should you need them, further details on the business arbitration scheme can be obtained from the Dispute Appointment Service at the Chartered Institute of Arbitrators. Thank you. That was all I wished to say, and I'm happy to take any questions.
So thank you, Nigel, for that presentation, which was very interesting indeed, particularly on that new development brought in by the Chartered Institute. I wondered if you could give us some examples, perhaps, of factors that arbitrators might weigh in the balance when they're considering how to deal with non-compliant parties. For example, if a party has been performing and participating in an arbitration up to, for example, an oral hearing, and at the last minute doesn't appear or doesn't perform, it would obviously be preferable for the oral hearing to proceed with that party performing, albeit that the party may present itself as not being able to do so at that particular time. What are the factors that arbitrators would weigh in the balance then, considering that position, the oral hearing coming up and being blocked out in everybody's diary and people having spent time and money preparing for it?
Thank you, Leonie. A very good question. I think the answer is a simple one. Much will depend upon the detail. If a party has been doing their level best to produce their case as and when required of it, then an arbitrator should have a certain latitude if they then, as it were, depart from the rails. Bear in mind what I mentioned earlier are only powers. They aren't obligations upon an arbitrator. They're merely things an arbitrator can do. Certainly from the experience of the cases I've done, where people don't take part properly, it's because they don't actually view the system either as one they trust for some reason. They don't understand it. Possibly they aren't legally represented, therefore they don't understand the legalities of it. Or they just don't think that the claim has, as it were, legs in the first place. And that tends to prejudice their response and their way that they act. But an arbitrator needs to press ahead with an arbitration, but not at the risk of being completely one-sided in doing so. So it's more a question of trying to understand whether the reasons for non-participation or non-attendance are really genuine, and obviously a health issue or an overriding commitment from a higher authority would be fair reasons. But if it is just felt that the party concerned is just doing their best to delay the inevitable, then the arbitrator, I think, should just move purposefully forward with the arbitration.
Yes, no, thank you. That's helpful. And another question which came to me was, is it? I mean, having had experience, if you have had experience of this this type of scenario, is it easy to tell whether a party is non-compliant simply on tactical grounds, or whether they have valid reasons why they might not be able to participate? Is it often clear?
It is normally clear not so much from the steps that they take or don't take, but from the email trail that precedes or indeed follows that taking part. Particularly if there are solicitors involved, they will normally be making legal points about why the arbitration shouldn't be allowed to go forward, perhaps because the appointment is questioned, perhaps because jurisdiction is under challenge, all that sort of thing. And so what the Act says is if you have this sort of concern, which are legitimate, but you have to express them as soon as you can. You can't sit on it and hope that actually you can bring it out as some sort of trump card later on. So these obligations, if you miss your timing, you lose your right to raise the points, which is the point the High Court made that I mentioned earlier.
Right. So we have another question that's come in from one of our attendees. Where the parties have the option, why should parties favour arbitrations over other forms of ADR, such as mediation or contractually binding expert determination, in your view?
Another good question. I was a litigator for nearly 40 years, and as anybody who litigates knows, the courts are getting slower and slower as the workload and their resources increase and diminish in equal measure. where you have high court fees now for doing anything, and indeed starting a case. Everything takes a long time, and there is massive uncertainty. You might get one judge, you might get a different judge, you might get a different decision, whereas with an arbitrator, you have an arbitrator fixed from day one the whole way through. Mediation is a very different beast, and I'm a great fan of it, and it has huge strengths. But bear in mind that the parties have to agree the outcome of a mediation, and sometimes they are at such loggerheads that that is realistically not possible. Therefore, having an imposed solution by an arbitration award is often the only way to go forwards. One would always hope, and I would certainly share that the parties themselves might retain enough of a relationship that they can talk about things as grown-up adults and try and avoid the uncertainty, delay, cost, stress, everything that goes with any of the dispute resolution options, including arbitration. Sadly, human nature means that doesn't always happen.
Thank you. Do you find that the time, my experience professionally of arbitration was that the timings, in fact, certainly of international arbitration, didn't differ drastically from court proceedings. But it may have been because of the number of arbitrators involved and the practicalities of the arbitrations that I was involved with parties from different jurisdictions and sometimes different institutions and their particular rules making a difference. Do you see any particular advantage with arbitration under particular rules from a speed perspective?
A very good question. Yes, bear in mind, I am only qualified as a domestic arbitrator, so I do arbitrations within England and Wales, not international. I have always thus far been the sole arbitrator in the disputes I've arbitrated, which does make things a lot simpler, a lot slicker, and a lot quicker. You don't have to get consensus from your colleagues. If parties are in different countries, clearly that does complicate things, and there may be issues of law that come into play that wouldn't happen if it was just domestic arbitration. My only real comment to address the heart of your question is that as arbitrator, I always try to fix a harsh but realistic timetable that makes the parties work hard to move the arbitration forward, and then I will police that they comply with it. Yes, things do get missed, things don't happen, and there may be good or there may not be good reasons for that, but it is not like a court where it's up to the other party to go to court to get an order. I'm actually sitting on both parties, or all parties to an arbitration, pushing them to do what they have to do, because I know that once deadlines get missed, then cost does start to rise really very harshly.
Thank you. And we had one question actually in advance of the session put to us in writing, which was from a trainee who asked, what avenues are there for solicitors joining the profession to get into alternative dispute resolution and I think arbitration specifically? What are the avenues that you see for trainees and for developing solicitors to get experience of arbitration?
Well, an entirely understandable question, and one that I sympathise with completely. In essence, if you don't do dispute resolution within your work, you won't easily establish the core of experience of that and a reputation for doing it, which will enable you to move into other dispute resolution areas such as mediation, arbitration, etc. However, that's a bit chicken and egg, so perhaps not very helpful. There are various things you can do as someone starting out on a career, whether it's legal or otherwise, who wish to get into alternative dispute resolution. Firstly, you need to be trained, and there are a lot of training courses some run by the Institute themselves on arbitration and indeed mediation, others on mediation by other providers. And I would encourage you to look at the cost of that, because that will let you learn not only the requirements of the particular dispute resolution method you wish to study, but also it will enable you to have, when you qualify, something to sell to others who wish to use your services. If you can't do that easily or quickly, then one thing you can do relatively inexpensively is join various institutions. And the one I suggest might be appropriate is the Institute of Arbitrators. If you're a student, you can join as a student member for very little money, it's a few pounds. If you're further on in your career, you can either join as an associate, or you could train up and take your exam, and then you could join at member level. You can't, as a student member or as an associate member, conduct arbitrations, but those who've reached member level can conduct them. The problem is you need to have contacts and a reputation which will enable you to be approached by the parties or their solicitors to be appointed. And that's obviously not easy to achieve. Once you become a fellow of the Institute, however, you are entitled then to join the other panel arrangements with the likes of the Law Society, the Institute of Accountants, and indeed, once you become a Chartered Arbitrator, the Institute's own panel. And therefore, if they get approached for appointments, you can then be appointed. I would encourage anybody who is interested in ADR, whether it's arbitration or in fact wider, to consider that. There is a local branch of the Institute of Arbitrators called the Western Counties branch, which covers all, certainly the Bristol area and all points south and west of it, which would then administer your membership. I sit on the committee of that branch, and it is quite active, and I think would be helpful to you. If you can't do either of those, but you are doing work within a legal environment, and you come across an alternative dispute resolution process, whether it's mediation, arbitration, or whatever, and it's got something unusual about it, then I'd encourage you to try to write an article and try to get it published, just communicating your interest in this area and this point. It will just help your reputation to spread and to grow. There is no, I'm afraid, no magic wand to wave, but it's a question of casting your manner on the waters as widely as you can, as often as you can, and hopefully it will bear fruit.
That's very good advice. We just had one comment in the chat about the institute that you mentioned there. Was it the Western Institute, did you say?
Yes.
Yes, so Western Institute of
sorry, there is, the Institute of Arbitrators has a number of branch committees which cover England and Wales geographically. The one within which Bristol falls is the Western Counties branch.
Western County branch. Hopefully that's answered that person's question. So we just have time for one more question, and I'll read it out to you. In terms of international enforcement, even for domestic jurisdiction decisions, does the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, known as the New York Convention, make arbitral awards preferable to other forms of domestic dispute resolution where one paying party might be based outside of our jurisdiction? So that's a taxing question there for you.
No, that
Let me
was
to repeat it.
A nice. No, that's fine. And a nice left field question right at the end. I think it does. Certainly the commentaries I have read recently, particularly with Brexit coming into the equation, did tend to suggest that arbitration awards are going to be more easily enforced post-Brexit than necessarily will be the case for litigation awards.
Well, that's good news. Good news for practitioners and good news for parties, I'm sure. Right, well, thank you very much, Nigel. That's been a fascinating talk, and thank you for your detailed answers to our questions this afternoon. So it just remains for me to thank you very much for your talk and your attendance, and to those who've attended and posed their questions from the audience. So thanks very much, everybody, and we look forward to welcoming you again at our webinars in the future.